So good afternoon and welcome to the latest MGAA webinar. I think this must be our 27th or 28th of this remarkable year, but we're very pleased to have you join us today. And today we are hearing from another supplier member in the name of Brown Jacobson. And today we're hearing about mergers and acquisitions and legal risks and solutions. Gareth, could you just nip to the next slide, please?
Sure.
Thank you. So as ever, just a bit of housekeeping. So all participants are automatically muted to reduce and keep the background noise to a minimum. We do like to have these webinars as engaging as possible, so please ask a question throughout the presentation just by wiggling your mouse, and a bar should appear. If you click on the chat function and just type a question, will come through to me, and I will raise that at the Q&A section of the presentation. For full clarity, the webinar is being recorded and will be uploaded as a podcast on our website. And then finally, we will be sending around some feedback forms, so please just take 2 minutes just to complete that following this webinar, just so we can understand if there's anything we can do differently or anything we just need to keep on doing. So without further ado, I will pass over to our main speaker today, who is Gareth. Over to you, Gareth.
Thanks very much, and good afternoon, everybody. Thanks for finding the time to join this afternoon. I'll just give you a brief introduction to myself before we go on to the firm and then this session. So I am a M&A partner in our corporate practice. I'm also a member of our FSI sector group, our Financial Services and Insurance sector group. I joined Brown Jacobson in 2018 from DLA Piper in London, and I specialise in UK and international private equity and M&A transactions for large corporates and SMEs. I also advise on private equity fund formation and other matters relevant to corporates. A bit about the firm before we crack on. So we are what I like to consider ourselves as a national powerhouse. We have 5 offices across London, Manchester, Birmingham, Nottingham and Exeter. We have over 500 lawyers now, including 146 partners, operating across 6 main target area markets, which include education, health, government, large corporates, financial services, and insurance companies, as well as SMEs. For those who study these things, we are a Legal 500 and Chambers top-ranked practice, and in terms of us knowing what we're talking about, hopefully, in 2019, we were ranked 14th across all law firms. That is, every law firm registered for the number of M&A deals done. The most recent completed disclosable deal relevant to today's session is the Clear Group's acquisition of Brokerability. In addition, we've acted on 20 plus acquisitions and disposals of regulated intermediaries during the past 2 years, and you'll see some awards that we've won very recently. So, what is the purpose of this afternoon's session? So we're going to cover or look at some of the legal risks relating to an M&A transaction. What are some of the legal risks on an M&A deal? We're going to cover due diligence, what it is, what a DD process looks like and why do it. We're going to look at some solutions to actual or potential risks, and then have a Q&A at the end. So I just want to state some of the learning objectives from the session. So hopefully delegates will be aware and have an understanding of the common issues and risks that can be present on an M&A transaction. The delegates listening, watching will be aware and have an understanding of the various options open to them if they were a buyer in terms of solving or protecting against such issues and risks. And that delegates will be aware of market practice relating to such protections, so that they are fully aware of the reasonableness and likelihood of the success in terms of asking for and negotiating any such protections. So, legal risks on an M&A deal. So to set some context, we've put here our view of the essentials of an MGA business. So I'll leave it on the slide for a moment. Hopefully people are familiar with this, but hopefully it will set out the background as to why we have identified and laboured on some of the risks to come. So moving on then, we are going to look at some generic legal risks and some very specific risks to MGA transactions. Now, hopefully for those who are on the webinar, some of these will be relevant or make sense or understood, appreciating some may or may not have been involved in M&A projects, but when I start to run through them, hopefully you'll get a sense of the potential minefield that you can run into on an M&A transaction. So, first of all, are contracts. Are the contracts in place and signed? Do they contain onerous provisions, change of control provisions so that the contract could terminate on completion of the transaction? If not, well, you could walk into a target business that has extremely onerous contracts that you will have to service and support. You may find that they contain indemnities so that breach by yourself or the target you've bought puts you out of pocket. You may find that the contracts fall away if you haven't gone and sought the relevant change of control and termination or non-termination provision from the counterparty. People. Are all the key people engaged, or all of the people engaged, on correct legal terms? Are all the relevant employment laws complied with? Are all the key employees subject to restrictive covenants or not? Clearly, when you're buying a business, one of the major assets is people. Not having people tied down to the correct terms around notice and covenants if they were to leave, and not complying with employment laws can walk you into a huge problem in potential litigation and fines. Real estate. If it's a leasehold property, what are the lease terms? What is the financial position in respect of dilapidations that you're walking into at the end of the lease? Has the terms of the lease been complied with? Could you find that post-acquisition, the landlord looks to kick you out? Is there security of tenure? What that means is, do you automatically have the right to renew the lease or not? And if the lease is coming to an end, where does that leave the business you've acquired? And if it's a freehold property, does the target actually own the land that you're alleged to buy? And what charges is the subject? What charges is the title subject to? Again, the point here is if you are not and have not sought to properly due diligence the real estate that you're acquiring, you have no idea what the premises your target is going to occupy in the future or have in terms of liabilities. Regulatory, this will be a big one when we come on to the specific elements of an NGA. Has the target complied with all regulatory rules? What are the consequences for breach, fine, strike-off, no permit, no license? Are permits and licenses required to operate the target? Do we need the regulator's consent to the transaction? If you don't, might those fall away? And if not, what will happen without the premises, so without the permits and licenses? What will that lead the business to be able to do going forward? Without a permit, it may not be able to even run the business. Finance. What debt is there in the target and what are the terms? Will it be repaid at completion? And what penalties might there be for doing so? Can it remain in place? And do you want it to remain in place? The question there is you need to understand what you're walking into again. Is there a known debt in the target and how do you protect against that? The corporate structure. Is the corporate structure compliant with company law? Have all historic filings been made and have the company books been written up? A minor point compared to some of the issues, but again, you need to know what you're walking into and the potential fines and consequences for not doing so. Other generic risks. Tax, a minefield. Has all tax been paid? And have all tax laws and regulations been complied with? If not, where does that leave you with HMRC and potential fines down the line? HMRC have got up to 7 years to look back. You may find yourself 3 or 4 years into an acquisition period before HMRC come knocking on your door. IP, intellectual property. Does the target own its IP or does it license it? It's important to know what the company actually owns. What if it licenses it? What are the terms? Does the target license IP out? And what are those terms? And is the target infringing or does the target or ever infringe third-party IP? How do we find out and what are the consequences? If down the line post-completion you find somebody comes out of the woodwork looking to sue the target you've bought for infringement. A key issue is around IT and data protection and cybersecurity. Is the target's IT and cyber up to scratch? Is the target GDPR compliant? I'm sure you'll all be aware of some huge fines that have been levied recently, a very recent example being BA fine, 20 million euros. And a fine, just to make the audience aware, the fine for breach of a GDPR can be the higher of 20 million euros, or the equivalent in sterling, and 4%, this is a big one, 4% of the total annual worldwide turnover in the preceding financial year, and whichever is the higher. So you can see the likelihood here of great fines being levied against the target business you've bought for potential breaches or actual breaches of GDPR. Claims and litigation. It's important to know if the target you're acquiring has been subject to litigation now or recently. Litigation history and trends can reveal how a business operates and its approach to risk. If your target business is being sued left, right and centre, that may make you think or question the target's approach to risk and whether or not it's a business you want to buy. And ultimately then, pensions. It's very important to know what schemes or what pension schemes sit in the target. And is the target compliant with pensions laws and auto-enrolment? Could the target be subject to regulatory fines if not? And finally, ABC, anti-bribery and corruption. It's key in today's day and age to know if the target is complying with all relevant ABC laws. If not, you could have a huge potential problem around fines and reputational damage. So those are some of the generic legal risks, but they can all be relevant in any deal. We're going to move on to some of the potential legal risks relating to potential acquisition or disposal of an MGA. As part of a regulated industry, compliance runs through everything, in our opinion, an MGA does. In particular, here are some of the issues in our opinion. So, authorised or exempt. Exemption for MGAs normally relies on its appointed representative agreement, the ARA. With the principle, non-compliance with an ARA can undermine the exemption, leading to potential breach of the FSMA and note potential for criminal liability and AML sanctions. Permissions. Is the MGA authorised? If the MGA is authorised, does it have all the required permissions? We need to check. Are there any limitations on those permissions? And I pause to make a note here that on about 50% of the deals we look at in this space, there are issues with those permissions. The relationship with the regulator. So for authorised MGAs, have any regulatory rule breaches been notified? Should they have been? And have there been any non-routine visits or correspondence? It's important to know as a buyer whether there is history of a negative relationship with the regulator. What are the relationships with the customers and distribution channels? Are all of the documents up to date and fully compliant, if they exist at all? ... Is the MGA complying with product and distribution rules and the prudential rules? Again, it's worth a note here in terms of the likelihood of issues is that we rarely see a deal where the target is fully compliant with the rules relating to the distribution of insurance products in one way or another. So again, it's something to look at and check as part of your due diligence. Further specific MGA regulatory issues would include the relationship with the insurers. Is everything properly documented? And if not, how does any party to the transaction know what the terms are? What's the position with client and insurer money? Is this dealt with properly in all of the agreements? And are the processes that the target operates actually robust enough? We've never seen a deal in which we have not identified client money issues. So again, something to note. And what about systems and controls? Are all of the above things we've just touched on covered by robust policies and procedures, systems and controls? And if not, we need to consider the notification rules coming on next. The final slide on MGA specific risks include quality of contracts. So generally, in our opinion, they're very poor in the sector. There's an over-reliance on standard and often outdated template agreements that can lead the target company and the buyer, again, as a point I made earlier on, in real potential difficulty around what terms the parties seek to rely on. Obviously, when things are good, there tends to be no issues, but in the bad times, reliance on contracts is a big issue. Proprietary information and ownership. Who owns the customer is key. Under what circumstances can the MGA or the insurer contact them directly? Point to note here is you need very tight controls on this, because introducing brokers will understandably want to retain the customer ownership, but equally when selling direct to the market, the MGA will want to retain ownership because the customer base is the business. I touched on it in the general section, but data and GDPR is a big issue in all MGA or MGA relevant acquisitions. This is because a significant amount of data, often including data in special categories, is in play. And it's important to know what the various parties do and can do with the data and who is ultimately liable for a breach. The point here is that MGAs will collate huge amounts of data which can include health records, financial details, criminal convictions, etc. And these are often shared amongst many parties, including the broker, the MGA, the insurer, and third parties, with often insufficient controls over who is processing that data, who is controlling that data, and what the various players are entitled to do with that information. There is a carve-out for legitimate business interests, but it's not the silver bullet that most clients and MGAs seem to think it is. So, notification. A deal consideration around notifying the regulator is going to be a key issue. For exempt MGAs, the notification duties fall on their principal, but the notification obligations, but do note the notification obligations on individual senior managers and approved persons. And the question then crops up is, should this be done pre or post completion? This is often a major consideration during the transaction and can become one of the most contentious issues. If a regulatory breach has been identified during the DD process, then there will often be a discussion around whether it's a notifiable breach, and if so, when and by whom. So vendors will usually try to push it to post-completion after you've signed, and buyers will usually want the vendors to notify beforehand, importantly to flush out any issues the regulator may have before it signs on the dotted line and the buyer becomes liable for any of those breaches. Notification properly. Usually you would be saying to the regulator that a breach has been identified during the DD process, spelling out what is proposed to be done about that to repeat occurrence and get the regulator to sign off on it. Do note though that the FCA may ask why a breach of the regulatory rules was not identified beforehand under the current owner's watch before the sales process, which can lead to a challenge around the effectiveness of the MGA systems and controls. Again, another issue for the buyer to think about in terms of buying a business that is clean and it can take forward without likelihood of challenge. So hopefully that is a run through of, I'll just scroll back, some very generic legal risks that you may find yourself looking at when you are looking to buy a competitor, another MGA, or a bolt-on acquisition relevant to your business. Some generic risks, and there are some specific regulatory risks that we've called out. I'm going to move on now to thorough due diligence. So in order to try and prevent some of the issues that we've just talked to actually biting or becoming issues, inevitably on every deal you should be doing due diligence. So why do it? Hopefully that's clear, but you need to understand what it is you're actually buying. Is the business as viable beneath the surface as has been presented? Now, often it will not be, but that may not be fundamental to whether or not you proceed. Some questions to ask would be, is the valuation on which you have based your investment acquisition verifiable? Is the target actually worth buying from the information you found during due diligence, whether that's regulatory issues or other issues? Is the business scalable? How does the business contract with its customers and suppliers? Does it even contract on written terms or not? What is the extent of the workforce? Are they engaged on sensible terms? Who are the key people? Are they incentivized and motivated? Could they leave on short notice, leaving you in a pickle? And where is the value in the business? Is it owned or licensed? And what if it was licensed? If the license terminates, where does that leave a business? Are there skeletons in the closet? which could have a financial or reputational impact on the businesses. I think the key point to note here is that reputational impact is becoming critical. Financial impacts can be dealt with, but damage to brand is critical in terms of going forward. We've seen it recently in some businesses not relevant to your sector. If you take Sports Direct, for example, the brand has been battered. So how a business reputation looks and how it operates is very, very important in due diligence. And are any consents required prior to your investment within your own governance, constitution, or otherwise? What sort of DD would be done? Financial, commercial, legal, tax, IT, political, etc. Multiple providers can end up providing due diligence reports on a company. The question, is it really worth it? The question is answered by this point. The impact of doing nothing. Buyer beware. You are absolutely on the hook in English law transactions. So you need to be understanding of what you're walking into. The final point here is, though, is how far should a prudent investor buyer go with due diligence? There's a proportionality and link between due diligence and the warranties and disclosures, which I'll come on to now. But hopefully it's key already from the presentation that by not doing a thorough level of due diligence, you will potentially walk into multiple skeletons in the closet, which will be your problem on your watch. So a brief overview of the due diligence process would be something like this: an initial review of the pre-offer information provided to you by the management team, management meetings, discussions between the buyer and their advisors, scoping out wider due diligence exercise, site visits, multiple due diligence inquiries back and forths, feedback and Q&A sessions with management to plug the gaps, ultimately leading to the issue of reports and factual accuracy letters, leading to you then deciding what you want to do about any issues that are raised. So, what are some of the solutions? We've now covered the multiple general and specific risks, and how might you as a buyer or bidder of a relevant business look to solve some of these risks? We've tried to categorize them into two camps. One is a pure financial price chip. You may be able to evaluate the financial impact of an issue and change the price accordingly. Or you may well need to seek to enter into a split exchange and completion, or a split signing and closing process, so that you can go off and seek comfort. And what I mean by that are, you may go and seek a regulatory approval or confirmation. We discussed before around some of the issues, and you may want a clean bit of health waving through from the regulator if they're willing to do that. Pre-completion comfort and actions, there may well be non-notifiable issues that have been raised, but you want the sellers to sort out in the gap or before you complete the deal. There are then 4 other areas, amongst others, of contractual protection you can seek that will deal with issues going forward, which we would call out as warranties, indemnities, escrows, retentions or holdbacks, and then a earn-out or deferred consideration structure that would allow you to shift value towards the end of the transaction and hold it back if issues arise. So let's look into some of these in a bit more detail then for the last part of the session. So warranties. In the context of a share deal, they are not the same as you may well find in other documents, or you may well see in a more general sense. So what are they and what is their purpose? So the starting point, as I identified before, is that the buyer beware. The buyer must beware on doing a UK or even European, for that matter, share acquisition deal. So the warranties equal some form of buyer protection. And a warranty in this context is a contractual statement of fact in relation to the ownership and state of the business given by the sellers, or some of them, as at a given date. And I'll come on to what that looks like in a moment, and I'll give you an example. But you are asking the sellers in a sale and purchase agreement to give you pages and pages and pages, often more than half of the document will be factual statements that you ask the sellers to stand behind, of which they are then able to disclose information against that warranty to you. And where they don't, and an issue arises, you have the right to sue them. Warranties have multiple functions. They are Firstly, they are there for information gathering. So you will have done your due diligence, but you will also flush out lots of information from the warranties. The warranties will be drafted in a sense, which I'll come on to now, but they will be framed in a sense of there is no litigation in the target. Now, you will know that. You may well have got comfortable with that risk through your due diligence, but in order to back that risk up, your solution will be a warranty that says there is no litigation in the business, and the sellers will sign off on that. And if there was found to be litigation, the solution would be you would have a contractual claim against the sellers. There are other ways of dealing with warranties around risk allocation and price negotiation. What that means really is that the risk allocation would be, are the vendors or are the sellers willing to give you a warranty to cover off the risk you've identified or not? And once you've identified those risks, who sits on top of that risk? You as buyer will be expected to accept some risks. And a price negotiation, as you determine more and more issues and more warranties come into the document, you may well feel the need to actually again renegotiate the price in order to be comfortable, notwithstanding the warranties you've asked for, that this is a good deal. A note of caution though is that warranty claims are very hard to bring. Across our M&A group, we probably see under one a year, to put it in some context. And in the 15 years I've been doing this, I've seen 2. So it goes to show you that it is a solution in terms of drawing out information, but where, as a solution, the risk bites, they are not always the best mechanism for recovery. The point being here is that you need to actually prove a loss of value in the shares, not just the actual loss of a thing that's happened. And there's a big difference, because it may well be, notwithstanding there's an issue in the business, a court may determine that you were still, or any other buyer would have still paid the same for the business. So here is an example then. So the sellers will be asked to sign off on this statement. There has not been, and there is not currently pending or threatened, any litigation or claims by or against or relating to the company, any assets or properties of the companies, the shares or the business, or the company's use of the leased premises. So what is it seeking to achieve? As I just said before, it's really seeking disclosure of any such litigation or claims. Now, it may well be the sellers have nothing to disclose against this warranty, and we move on. But if you are concerned about potential claims, which you inevitably will be, asking for it is the starting point to address the risk. As I say in the next bullets, if there is no disclosure and there is litigation in the target company you buy, as the buyer, you have the right to sue and recover from the sellers. It is essentially a form of post-completion and post-payment of the purchase price solution. By obtaining warranties for all or most areas of concern or risk, you will either flush out a disclosure, allowing you to seek upfront remedy or solution, or sue for recovery after the event as a solution if there is a breach of warranty. But do caution. The latter part here is that if you think the best solution is a warranty, you're probably mistaken on a specific issue. And the final flag is that, as I said before, warranty claims are difficult to bring, and they do tend to be subject to, in English law and European sell and purchase agreements, they are subject to multiple liability limitations, such as de minimis and baskets and the like. What that really means is that, I don't know, say you agree, say you buy a business for 10 million, you have a liability cap of 10 million, you won't be able to bring a claim from £1 up. Often sellers will negotiate a cap you have to get over to bring a claim against them. So a likely cap on a 10 million deal might be £1 million. So you'd have to get over that £1 million claim value to even bring a claim. So hopefully you can see here that warranties are the starting point maybe of solving some contractual risk, but they are not the end game. So that moves on to indemnities then. So you may or may not have heard of indemnities in a share or asset sale context, but these are relevant where you have identified a really specific issue in the course of your due diligence, and you are asking the sellers for a contractual statement in the document that does obtain you pound for pound recovery. So it is not subject to, using the previous example, the £1 million hurdle. And you do not need to prove, which is the relevance here, you do not need to prove loss of value to the shares. You just need to prove the thing happened. So using an example is, was there a piece of litigation in the business? The seller said there wasn't. It turns out that the business is being sued for £100,000 claim, slam dunk. If you had an indemnity for that, you would get your £100,000 back. If there was a warranty claim, you may or may not, is the point there. Second bullet is that indemnities are typically not subject to limitations on liability. You will sometimes see a time limit or a overall cap. They are not subject to the multiple caps that you will see with warranty claims. All sale, whether it's share or asset purchase agreements, will contain a tax covenant and a tax deed, which is a tax indemnity for unpaid tax. So in English law and European law transactions, you will always see a tax indemnity for unpaid tax. Given indemnities are essentially pound for pound recovery, they are often hard fought over by sellers. They will not give them unless it is a slam dunk issue that inevitably would bite, albeit it will bite in the future. They are a great solution notionally where the seller is going to be solvent at the time of an indemnity. You may well find though that your business you're buying is being sold by retirees. So the question is, they're giving you an indemnity, but have they any money to pay it? Or you may be buying a business from a corporate carve out, and again, you've identified a specific risk of concern. You've gone through all the pain of negotiating the indemnity, and you find out in 2 years' time when you come to call on it, the corporate or the retired vendor has no money. We'll come on to how you may address that. Fact check here is that in 2019 in the European M&A market, not the US, 64% of deals had specific indemnities on them. So what hopefully that shows you is that it is typical, because this is the third learning point, it is more than typical where you have identified risks that you can get indemnification from sellers. And this is an example of what an indemnity looks like. I'm not going to read it, but hopefully you can see it's framed slightly differently to a warranty, and it is very wide in terms of what the sellers will indemnify the buyer for. The X here is the issue. So the wording before the X is the prelude to the contractual element. The X would be, in respect of litigation or breach of GDPR, etc. So I'll give you a moment to read that, but hopefully you'll see just on a quick read compared to the warranty that I'll flip back to, it is a much stronger contractual statement. So if we take it a step further, where you have identified an issue that isn't resolvable with the regulator before completion, and you may or may not have sought a price chip, but it is an issue of concern and you have managed to get the sellers to sign up to the fact it's an issue, then where it is a real material concern, in addition to asking for warranties and indemnities, you should consider asking for an escrow or retention or a holdback. And what this fundamentally is where a percentage of the purchase price, whatever percentage the parties agree, is then deposited into a third-party escrow agent account. Now, it can be the lawyers on smaller transactions, but with the SRI rules as they currently stand, law firms do not like to hold those monies. So you may have to go off to a third-party escrow agent, JP Morgan, etc. And they will hold that money on account for both parties and only release it upon a specifically agreed event, i.e., this litigation you think was going to happen doesn't materialize, or the regulator doesn't bring a claim against you for breach of the FCA, or it doesn't bring a claim against you for breach of GDPR. So money's locked up. The main issues with escrows or retentions, because they sound great, generally is for how long will that money be locked up? A massive issue for sellers and buyers alike. And what happens at the end of that initial period? Because you may well find is that you agree to lock the money up for, say, 2 years, but that within those 2 years, the litigation has not, or has maybe started, but has not actually gone fully pledged. Are you as buyer happy that that money is released, or do you want to sit on it? So whilst conceptually it's a good idea, it does then lead into a number of other conversations and negotiations in order to get comfortable. What you don't want to find, of course, is that you've identified an issue, agreed a retention or holdback, and then you have to release that money, and then the issue still bites. So that is an escrow and retention. A holdback concept is very similar. It's a US deal term creeping into the European M&A market. And for just general ease, rather than paying into a third-party escrow agent, the buyer simply agrees to retain X% of the purchase price and pays it over at the same point as if you had a settled escrow or retention. That is often done for transaction simplicity, because setting up a escrow or retention agreement takes time and costs money. But the point here is that the buyer, or you in the context of this presentation, would have sole control, but from a vendor point of view, from a seller point of view, is what happens if you become insolvent and are still sat on that cash. Fact check then, so in 2019 in the European M&A market, only 27% of deals had escrows and retentions. So hopefully you'll see there that in terms of indemnity protection, more deals than not will have this as a solution to risk, whereas with a escrow and holdback concept, only 27%. So obviously not the majority of deals have this. So it is, in terms of the facts, in terms of the learning outcomes, it is fair to say that you can ask for this as protection, but it is probably more likely than not to be given. A final issue then is potentially warranty and indemnity insurance, or W&I as it's referred to within the market. So certain deal issues or risks that you have identified can actually be insured. You can insure the general warranties and indemnities where a buyer fears the seller may have solvency or capacity issues. So in terms of backing up that comfort, rather than escrow, where the vendors say we're not giving you an escrow, you may be forced or have to come to a deal about who pays for it. So to give an example on a transaction I'm working on at the moment, it is a £200 million transaction, and to buy £60 million worth of cover, the fee is about, the premium is about £500,000. So it is expensive, but it can be a solution to the addressment of risk. Specific deal issues where the parties cannot agree on indemnities or escrows or holdbacks or the like can be insured by certain underwriters. So these can be very, very expensive. So it's not a general coverage. This is a very specific coverage, but they can be available and they can solve deal issues in the market. So a recent example on a transaction I worked on, that we found that the risk was there were invalid share buybacks, and there were issues around PAYE and NI claims in the business, going back to some shares that were acquired historically from an EBT. Now, all the parties agreed it was a risk, but given the makeup of the sellers, it could not be agreed to give a general indemnity or an escrow. It was a private equity seller. So we searched the market, and an underwriter did agree to cover this specific issue that PwC quantified at 3.3 million for a premium of £500,000. So it is expensive in the context there, but it is again a potential solution to risk where you've identified a risk, and the solution that you may want isn't open because of the makeup of the sellers. Private equity sellers in particular do not like to give SPA or sale and purchase agreement protection. Final fact check then. So in 2019 in the European M&A market, 25% of deals used W&I, and where a private equity seller was involved, 48% were used. So again, I think you can see that after price chips and split signing and closings in order to try and cover off risk, you've got your warranties and your indemnities, your escrows and holdbacks, and your W&I solutions are not typically seen. So more often than not, you won't be either asking for or getting these as solutions, but part of this presentation is to make you aware of what you can ask for, but also, and more importantly, to make you aware of what you will actually likely get. A final thought on how you may solve or look to try and solve a risk is that where this M&A risk relates to the underlying financials or an issue that comes back to the financials, and the bidder's risk ultimately relates to the price you're willing to pay or you need to pay in order to win the deal or get the deal, earn-out structures have become very common as a way of buyers protecting or hedging against that risk. So essentially, rather than paying 100 million or so for an asset, which is projected to make 10 million, you will strike a deal that sees you pay 75 million up front, with the balancing 25 million conditional upon, in my example, an EBITDA target being hit, but another target being hit, or some other thing not happening, or using examples that we touched on before, the GDPR claim not landing, or the regulator not fining you. The point here to note is that COVID-19 has seen multiple deals restructured as earnouts, where buyers can just not get comfortable on price and risk or other risks, and rather than having escrows and lockups or any content of having to pay that over, they just prefer to hold on to the cash and say to the sellers, we are chipping the price essentially, we need to hedge our bets, and we need to pay you the final balancing payment at the end of the transaction when everything is squeaky clean. The point here to make is at the moment in the current market, they are A, commonly seen, and B, commonly accepted by sellers. So the fact check there is that in 2019 in the European M&A market, only 28% of deals used earn-out structures. I think the point we make here is that in the last 6 months alone, we have seen multiple deals, so that percentage is probably likely to be at least 2 times, maybe even more. So in terms of ways of not using the pandemic to exploit contractual protections, but I think it is fair to say currently that buyers, in order to address or solve risks, a solution is to look at a structure that defers paying money to the sellers until 2-3 years down the end of the line. So I appreciate that was a very quick canter through what is a minefield of risks and an even bigger minefield of how you might solve them. But what we wanted to try and touch on in today's session was you being aware of and having an understanding of the common issues and risks that can be relevant on an M&A deal. So I think we've identified general risks to you and some very specific risks that can bite MGAs. We wanted you to have an understanding and awareness of the options open to buyers in terms of solving those risks. And we've spoken about price chips and valuation issues, or split signing and closings, where you can often try and get the issue sorted, whether that's through notification, regulator sign-off, pre-approval, etc., or moving into more contractual standard terms through warranties, indemnities, holdbacks, escrows, deferred considerations, earnouts, and the like. And finally, and more importantly, we wanted to make you aware of the market practice relating to those, and that comes with the percentages we've spoken about, and to make you aware of how likely it is for any ask around solving a risk, how likely it is you're going to get it. Because what we wouldn't want you to do is to come away from this, if you're looking at an MGA acquisition, is to say, let's get a slam dunk, earn-out structure with a load of warranties, indemnities, and hold back, because the likelihood is you probably won't get it. And that leads us on to, so we've gone for 45 minutes, that leads us on to questions. So happy to take questions if there aren't any questions for now, but people want to send them in. My details are at the start of the slide deck, or please send them in to the guys from the MGAA. So yeah. Is there any questions that have come in, or anything that you want us to, because one of my colleagues is on as well, wants us to revisit or labour, or just go straight into questions if there are any?
We have a few. We have a couple of questions that do come through. But as I say, and thank you very much, Gareth, for that. That was most useful. And if anyone does have a question that they want to submit, please just use the chat function, and we can raise that as when we get to it. As Gareth says, we also have Jeremy Irving on the line as well, who's able to answer questions that Gareth can't take as well. One for me at the moment, Gareth. So with the onset of COVID-19, how are you seeing bidders position risks, such as those outlined, in terms of their bids?
Yeah, sure. So what we are seeing is bidders being very cautious in terms of their approach. So what we are finding is that on most bids we work on, or we receive if we're on the other side, is they are asking for, as I said, earn-outs or some sort of deferred consideration structure. Where there is any sign of an issue, they want the sellers to go off and get pre-signing or pre-completion approval, so it's on their watch. We're asking for indemnities on pretty much every transaction, even where there are minor risks. The view is, why should a buyer swallow that risk in the current climate? And we are seeing a lot of reliance on warranty and indemnity insurance, where buyers will ask sellers to pay for that in order to put a blanket wrap around its risk profile. So I think if you're a seller in the current market, I think pre-COVID, it was a very hot market for sellers to almost push all of the solutions I spoke to away. In the current market, I think sellers are having to accept an awful lot in terms of buyer requests.
Okay, brilliant. Thank you. Thank you. And then just one final one that's come through then. So there's potentially one for you, Jeremy, or Gareth can take it. So on slide 13, when you say you see problems with permissions, what sort of things do you mean in that respect?
Thanks,
Jeremy?
Ben. Yeah, this is Jeremy. Hello, good afternoon, everybody. So I head the financial services team at Brown Jacobson, working in tandem with Gareth and other colleagues in the corporate team on deals in this space. So the issue around the permissions piece tends to be that for whatever reason, and sometimes it's been advice from lawyers, and sometimes it's been advice from compliance consultants and others who may be involved in getting a business up and running, an MGA up and running, is that the full suite of permissions which an MGA could have, and in most instances would sensibly have not been taken. So, for example, we often see the situation where the MGA has not obtained the permission to deal as an agent. Now, dealing as an agent is a permission which is usually required if you're going to take steps as an agent, enter into contracts on behalf of an insured. And a lot of MGAs will have business models, of course, which are geared towards acting solely as the agent of the insurer rather than the insured. Nevertheless, there can be situations which arise, even if unintended, where steps might be taken on behalf of an insured, and where we find that the practical reality when we're doing our due diligence is that actually the MGA, for one reason or another, possibly through its own agents, its appointed representatives, has been taking steps on behalf of insureds or getting very close to it, but doesn't have the requisite permission. This can cause an issue, and this can apply in other situations as well, in relation to advice. So again, we've come across situations where the permission in relation to advising has not been obtained, again because the MGA has set out with a strategy of only acting for insurers, but actually in the warp and weft of day-to-day activity within the marketplace, it or its appointed representatives have ended up giving advice to insured. So again, that creates a problem. You have a regulatory gap there. You have potential regulatory liabilities, potential questions around systems and controls. So very important in terms of due diligence, but also just in terms of general management of an MGA, to think long and hard about the permissions that are available, how they might come to need to be used, and indeed whether and of course whether you might need them at all.
Excellent. Right. Thank you very much, Jeremy, for that comprehensive answer. That's all the questions that's coming through, Gareth. So did you want to just make a few final comments and then we'll look to wrap it up?
Yep, thank you, Ben. So hopefully you have all found today's session informative and you followed it and understood it. But again, if you have any direct questions, not too much Q&A, but issues that you thought about or want to think about in respect of what we've covered, do email me. I appreciate it is a complex area with lots of issues in my field. So as I say, hopefully you followed it, but clearly what we want to try and address today is, you will inevitably find issues on transactions as we've suggested, and we wanted to inform you at an early stage of where you might go in solving those, either before or after you're talking to sellers and or lawyers, to try and put you in the best place possible in order to either win an auction if that's the way the transaction is going, or just give yourself credibility to ask the right questions and ask for the right solutions. So again, thank you for joining this afternoon. Appreciate everybody's busy. I said if Jeremy or I can be of any further assistance at all, please do shout.
Brilliant. Thank you very much, Gareth. And with that, I would just like to thank everyone for attending today, and thank you to Brown Jacobson for hosting. The next webinar that we are hosting is on the 2nd of November, and that is hosted by Genesis Technologies. That is on the insurance ecosystem and how to become part of it or go extinct. So if you're interested in attending that particular webinar, invitations have gone out already, or just go to our website under the All Events section. But thank you very much for joining today, and we'll end the webinar there. Thank you.